Davidson from Albertson & Davidson. In this video, we're going to go over a notice of hearing for a petition for probate. This is going to be form number DE-121. In a previous video, I went over how to fill out the petition for probate, which was form DE-111. And now that you have your petition for probate, the next thing you need to do is provide proper notice to everybody who's interested in the estate. So we're going to start off here at Google, and we just do a search for Judicial Council of California, and we'll go ahead and pull up the forms. So we want the court website, and that's what this is here. And then we're going to go to select a category, and all the forms we're going to use for our probate are going to be under Probate Decedents Estates, and we'll see the forms. For this purpose, we're going to want form DE-121, which is our notice of petition to administer the estate. And here it is here. So the form DE-121 is unique to a petition for probate. I have another video where I walked through a notice of hearing using form DE-120, and I said in that video that you use that notice of hearing for every purpose when you're giving notice of a hearing in a probate matter, and that's true except for a petition for probate. When you're doing a petition for probate, you have to use this form because this form gives you some unique information that the other form simply doesn't include. So the only time you're going to use a DE-121 is when you're filing a petition for probate to open a probate in California. So let's go through how this works. So at the top here, I put in my name and address. If you're self-represented, you're doing this yourself, you just put in your own name, your own address. Here I put in the client that I would be representing, Bob Smith, made-up client. If you were representing yourself, you could either put pro per, or you can just put your own name in there. Keith Davidson, attorney for Keith Davidson. Everybody understands what that means. But we're going to keep it Bob Smith for now. There we go. And then we're going to do the estate of Rachel Smith, Bob's wife. And this is where the notice begins. And you can already see, if you look at the DE-120, you can already see that this notice is very different. Just the layout of it and the information it provides is quite different. So this is a notice of petition to administer the estate of, which we already said estate of up there, but they want us to type it in again. And then the case number. So by now you should have the case number because you're going to give notice of the hearing date, and you're not going to get your hearing date until you file your petition for probate. But a lot of courts are going to want you to have this form filled out, and they're going to want you to submit it to the court at the time you file your petition for probate so that the court can stamp in the dates. Some courts want you to do that, some don't. So what you should do is have this form ready, take it with you to the courthouse, and if you don't need it, don't worry about it. If you do need it, then you'll have it. You are going to need it eventually because you're going to have to give notice to everybody. So we have our case number up here. And then it starts off saying to all heirs, beneficiaries, creditors, contingent creditors, everybody who might have an interest in this estate. And they want to specify all names by which the decedent was known. And so we just have the one, but I guess if you had multiple names, you could put them here. And then they're giving notice that a petition for probate has been filed by, and they want the name of the person who filed that petition. In our case, it's going to be Bob Smith. And they want to know in what court or what county it was filed, so everybody knows where to find this probate action if they want to appear and do something. So we're filing in Los Angeles County for this one, just as an example. If you're in San Mateo, Santa Clara, San Diego, Orange County, just type it in there. The petition for probate requests that, and this is where you're going to put in the name of the person who you want to act as the personal representative. Personal representative is just an umbrella term that we use to describe both executors and administrators. An executor is somebody who's named in a will to manage the estate. An administrator is everybody else who's not mentioned in a will. Or if you have an estate with no will, then the person managing that estate is the administrator. They're all referred to as the personal representative. So in our petition for probate, we had asked that Bob Smith be appointed as the personal representative. He happens to be both the petitioner and the personal representative. They're not always the same. So Bob Smith was filing a petition trying to open the probate, but the will says that somebody else is supposed to be the personal rep, then you would type in that other name right here, and that'd be fine. That's no big deal. Number 4, the petition requests that decedents' wills and codicils, if any, be admitted to probate. So if you have wills, then you're going to click number 4. If you're doing an intestate estate, meaning somebody who died without a will, then you don't have to worry about number 4 because you're not asking that a will be admitted. Number 5, the petition requests authority to administer the estate under the Independent Administration of Estates Act. So we talked a little bit about this in our petition for probate video. There's an act, it's quite long, under Probate Code Section 10,500. You can find all the particulars. And what the act does is it allows the personal representative to take certain actions without seeking court approval first. And so it gives the executor a little bit more freedom. There's still a lot of things the executor can't do without court approval, like making distributions of the assets or paying themselves for a claim that they might have against the estate. But there's a lot they can do. So the law wants us to tell everybody in the world when we're giving notice that we're asking that the personal representative be given this independent power. So that's something that is very important that you check if you're asking for it in your petition for probate. Now, if for some reason you're not asking for independent powers in your petition for probate, then you can just leave that blank. But do not make the mistake, and I've made this mistake when I was early in my career, where I asked for independent powers in a petition, but I didn't check this box on the notice, and the court simply won't hear it. They'll require you to reserve this notice, and they'll continue the hearing out, and just it causes a delay in time. So I learned very early on that these forms are important and these boxes are important, so make sure you take them seriously. So if you're asking for that power, just go ahead and click that. Now you have to fill in when the first hearing is going to be, and that the court will give you that. So let's say that our hearing is on November 1, so we're going to go ahead and type in November 1, and let's say it's going to be at 9:30. And Department 11, we don't have a room number, so we'll just leave that blank. If there is a room number, then you'll fill that out. And then they want to know the address of the court. Most of the time, it's going to be the same as noted above. So I had already filled this in, but right here I have the street address and the mailing address of the Los Angeles Downtown Courthouse. If the addresses are different, you have to put in the right street address and mailing address. You can find these on the court's website. So down here, all it's asking is, well, is that where the hearing is going to be held, or is it going to be at some other address of the court? So most of the time, it's going to be the same as noted above, and you'll just click that. Now on number 7, it's just giving everybody notice that if you object to the granting of this petition, then you really need to appear and state your objection. And if you don't, then you're going to waive your objection. If you're a creditor or a contingent creditor of the decedent, then it's telling you you must file a claim with the court within these time frames. So 4 months from the date when letters are issued. And we're going to talk about letters of administration or letters testamentary in a separate video, but there is another document that you're going to see that you have to have in your petition, and we'll go through that. But this is just, number 8 is just giving creditors notice of all this, of what they have to do. Number 9, you may examine the file kept by the court, and it talks about how to do that. And then number 10, the petitioner or the attorney for the petitioner, and you have to put in your name and address so that people know how to contact you. So if a creditor wants to file a creditor's claim, they have to know where to mail that claim. And so that's why we're going to put in this information. If you're representing yourself, no problem. You'll just put in your address where you get your mail so that you can get the creditor's claims or any other objections that people might have. And then you have to make sure you put in your telephone number so people can reach you there. And then you should be good to go. Page 2 here, the second part, this is the proof of service. So this is where you're going to be signing under penalty of perjury that you took these actions. So it's important that you fill this out properly and that you actually do what this form says that you're going to do. So first of all, you have to be over the age of 18 or else you can't give notice. You have to be a resident or employed in the county where the mailing occurred. So you can't go to some county where you don't work or live to mail it. You have to mail it where you work or live. And then you have to put in your address. So you can use your business address if you want people to notify you there. You can use your home address. I obviously would use my law firm's address because that's where our mail goes to. And I'll just put it in. And that way people know how to get a hold of us. And then number 3, I served the foregoing notice of petition to administer the estate on each person named below by enclosing a copy in an envelope addressed and shown below, and you either deposited it with the post office yourself or you put it into the mailing process at your work. So a lot of businesses, corporations or big law firms, they have a mail department. You may not be the one who actually puts it into the post office or the post box or gives it to the mail person, but you put it within your mail system at work, and you know that that mail system means that it'll be mailed on the same day with postage prepaid. You have to make sure you know that if you're going to check box B. If you don't know that, just deposit in the mail yourself with the postage fully prepaid, and that way you know that you did exactly what you said you were going to do. And then let's put the date that we're giving notice and the city and state where we mailed it. That's where we gave the notice from. Now, number 5 is important. It says that along with this notice, you also sent a copy of the petition or other document referred to in the notice. Well, the petition that's referred to in this notice is the petition for probate, Form DE-121. And you're going to have to fill that out and file it with the court anyway. We strongly recommend that you check number 5 and that you send a copy of that petition with this notice. That way people can't complain later that, well, I got the notice, but I didn't get the petition. The court might continue the hearing to allow people to get a copy of the petition. Do yourself a favor, make it easy on everybody and easy on yourself primarily, and just check this box and send a copy of the petition for probate with this notice. You'll be happy you did. It makes it real easy. And then you're going to put the date that you signed this. It doesn't necessarily have to be the same day that you mailed it. Some people say it shouldn't be the same day as you mailed it, although most of the time it is, because you'll mail it and then you'll sign this form. And then down below, you're going to put the name and address of every person who's entitled to notice. If you can't fit it in with these 6 lines, you can continue it on an attachment. We almost always use an attachment because it's just easier to keep track of people that way. And if you have it on a separate Word document that you attach to this notice, you can use that separate Word document for other purposes in your probate. And you will need to serve it with various different forms. So sometimes it's easier just to use an attachment. I always type in "see attachment" up here just so people know that we're not just leaving it blank. It's easy to miss this little checkbox down here. So I just say "see attachment." Now, it's important that you send this to everybody who's entitled to notice. The people who are entitled to notice is everybody named in the will. It doesn't matter how they're named, doesn't matter if they're current or contingent beneficiaries. If you see a name in a will, doesn't matter even if they're successor executors. If you see a name in a will, give notice. Just send them notice. And then you also have to serve notice on all heirs at law, even if they're not in the will. So let's say a decedent has children, but the children aren't receiving anything under the will. You still have to give those children notice. So make sure you serve notice on everybody named in the will and everybody who's an heir at law, which would usually be a spouse and children. If somebody passes away and they don't have a spouse and they don't have children, then the heirs at law might be the parents. If they don't have a parent, then it's going to be their brothers and sisters. And so make sure that you include those people. It's way better to give too much notice than not enough notice, because if you don't get enough notice, the court can't hear your petition and the court will never grant it. So you're better off over-noticing. And so make sure that you notice everybody. At the end, you're going to print this form, you can save it, and ultimately you're going to file it with the court. So the whole purpose of this form is to notify the court that you took the actions that you said you did under this form. So this blank area up here where it says "for court use only," that's where you're going to take it to the court. The court's going to stamp it and file it, and then you will have proof that you gave proper notice to everybody. If you don't have this form DE-121 served and filed with the court by the time your hearing comes along, the court simply will not hear your petition because it can't. It doesn't have the power to hear your petition until proper notice is given. So this form is crucially important. So make sure you fill it out, mail it out, and file it, and then you'll be good to go.